Law is given before it's made. Legal statutes and social contracts aren't crafted in a moral wasteland. They're born accountable to a higher natural law, and their word is neither first nor last. If that were not so, the Nuremberg trials were nothing but victor's vengeance dressed up in a fiction of justice. And today's high-blown rhetoric of universal human rights is just so much wind. That is the moral realism that the Christian doctrine of just war, both early and late, takes for granted. It assumes that there is a universal moral order that transcends national legal systems and applies to international relations, even in the absence of positive international law. When I use the word positive, what I mean is man-made or conventional. Positive is posited by human convention. This Christian doctrine believes that there are human goods and moral obligations that exist in and with the nature of things in some sense, and which exercise a guiding and constraining moral authority long before human beings articulate them in statutes or treaties. It holds that the principles of moral law are given before positive laws are made. So the tradition is well expressed by Hugo Grotius, and it is contrary to Thomas Hobbes. One thing this implies is that military action can sometimes be morally justified in the absence of, and even in spite of, statutory or customary international law. For that reason, the doctrine's proponents can't join those, including philosophical proponents of just war, who believe that the legitimacy of military intervention to prevent or halt grave injustice is decided simply by the presence or absence of authorization by the United Nations Security Council. Positive law can't have the final word. A common objection to appeals to natural moral law is that it is indeterminate and controversial. Positive law itself, however, is not beyond controversy, as we'll see shortly. What is more, one truth made manifest by the experience of Nazi rule is that the murderous killing of the innocent on a massive scale can be legally permissible, and its condemnation therefore requires appeal to principles of justice that go beyond positive law. Before the Second World War, the professor of law and politician Gustav Radbruch was a legal positivist. In 1946, however, he wrote a now famous essay, Gesetzliches Unrecht und übergesetzliches Recht, legal injustice and more than legal justice. In this he argued that there can be cases where the discrepancy between positive law and justice reaches such an unbearable degree that the former must be deemed wrong. Indeed, there may be cases where positive law doesn't even attempt justice, and where equality is abandoned, in which case the statute doesn't partake of the nature of law at all. That, he wrote, is because law, including positive law, can only be defined as an order and statute whose very meaning is precisely to serve more than legal justice. This view is now referred to as the Radbruch formula, which has been applied many times by both the German Federal Constitutional Court and the Federal Court of Justice, originally in cases concerned with Nazi crimes.